The fraudulent transfer laws, this is something that is kind of nifty because it has been around for a very, very, very long time. Our current law derives from the statute of Elizabeth, and I'm not talking about the Queen Elizabeth of today who walks around in a yellow dress. I am talking about this lady. In essence, William Shakespeare was writing Romeo and Juliet at about the same time the Statute of Elizabeth came out. Now, the UFTA, the thing to understand about it is that it is the stepchild of the U.S. Bankruptcy Code. And the reason I say that is because it is driven very heavily by definitions. And the definitions are, for the most part, cribbed completely from the U.S. Bankruptcy Code. The most important of the definitions that I'd like to talk about is probably the term claim. What is a claim? And I've got it up here on the board for everybody. A claim is simply a right to a payment. And it doesn't matter whether that right is reduced to a judgment or not. It doesn't matter if it's liquidated, unliquidated, fixed, contingent, disputed, undisputed, matured, unmatured, legal, equitable, secured, or unsecured. This is a very, very broad definition. A debtor is simply a person who is liable on a claim. A creditor is a person who owns a claim or has a claim. A debt is liability on a claim. The next important issue is, the next definition is transfer. What is a transfer? And it may surprise you that a transfer need not be a transfer of an asset. You can commit a fraudulent transfer by encumbering an asset. And here's the definition for a transfer. Every mode, direct or indirect, absolute or conditional, voluntary or involuntary, which, by the way, is where the federal judge got the involuntary transfer as potentially a fraudulent one, where the transferor, who's the debtor, parts with some interest or bundle of rights in property and gives it to a third party.